So you can go and kind of take a look and see what, at least in terms of the ministry's thinking, what they would typically expect to see in a set of bylaws. But your bylaws don't actually have to contain an awful lot because the legislation is actually so detailed. The legislation runs about 220 sections. So you could have 2 or 3 items in your bylaws and get away with kind of a minimalist approach to having kind of a minimum number of things in your bylaws, sections in your bylaws dealing with different issues, and then simply rely on the legislation.
So you'll still have to submit bylaws?
Oh, yeah, no, you don't have to submit the bylaws. No, if that's what your question is.
Yeah.
You've got to submit the articles if you're creating.
And they're going to have to include what now would be in my bylaws. I'm going to bring them into my articles.
Some things. So likely classes of members, a number of directors. There may be some other things. That's, again, one of the things that we need to do is wait for the regulations. Okay? Yep.
I'm curious about one thing. Since all of this is going to the Articles of Incorporation, let's say, for example, we've traditionally had people from all over the province. For the sake of argument, let's say they divided Northern Ontario into 2 separate regions, which would change probably the number of where we wanted our representation to come from or the number of our directors. Does this mean something like that would mean, oh, all of a sudden you have to reincorporate?
No.
Because we changed the number of directors or something?
No, and we'll get to that in, yeah. Another kind of element that has raised a lot of concerns in the sector is...
Just telling you to be quiet because I have questions.
Okay.
And we're running out of time.
Class voting. So there are certain... If your organization has more than one class of membership, and there are certain fundamental changes that might, let's say you're proposing to make a change in your articles that would take away some right that a particular class has under the articles or in your bylaws, then that class can actually vote on that proposed change separately. And in order for the proposed change to pass, it has to be approved by the class. Currently, if you've got, let's say you've got 2 classes, but they each have the same votes, but they may have some other rights or privileges attached to the class. Currently, there's no separate class voting. So essentially, if the majority feels that it's a good idea, then the proposal passes. This essentially will give classes a veto on certain fundamental changes to the Articles of Incorporation. And the third point is that in those, if the proposal affects the rights or privileges of a class that ordinarily is not entitled to vote, that class gets a vote on that particular question. So you can see that and this is again typically modeled on business corporations legislation, Canada Business Corporations Act, the Ontario Business Corporations Act, which give minority shareholders or shareholders that typically don't have a vote the right to vote in certain circumstances where the majority shareholders or the shareholders with votes are proposing and the board is proposing to make changes that will affect the minority shareholders.
I mean, it sounds like it's putting foot in the door for anarchy because it sounds like we could have a general meeting and an AGM,
Yep.
and it's packed by developers.
Yeah.
We say, okay, this is what we want to do, and we have no say.
Well, first of all, they have to be members. They have to be members of the corporation, right? So when I'm talking about members, I'm talking about think of a business corporation. You've got shareholders. Well, members are this sort of stand in the same position in a nonprofit where you don't have share capital. The members they have to be members. So they have to be part of the organization, but they may not ordinarily have a vote. Like they may typically, you may have an organization that has voting members and non-voting members. Yeah. But you kind of hit the nail on the head. A lot of people in the sector said that this is the sort of thing that could lead to anarchy or take over, or you get a small kind of rump within an organization that's kind of cranky, and they attend a members meeting and kind of all hell can break loose. So it is a provision that is controversial, and as we'll see in a moment, when we now talking about Bill 85, which is, as I said at the outset, is dead because of the election that was called. But Bill 85, one of the things about Bill 85 was, it said that the provision that gives non-voting members and members the class voting structure, we're going to delay implementation of that even when, after the Not-for-Profit Corporations Act comes into effect, those particular provisions within the legislation will be delayed in implementation for at least 3 years. So there's a recognition that the sector needs to kind of get its head around what this is going to mean in terms of dealing with the membership and governance issues. One hopes that when the legislature comes back and the equivalent of Bill 85 is reintroduced, that it will contain that provision. The other thing, so now we're getting into the issue of the transition. So under the legislation as it's the Not-for-Profit Corporations Act as it's currently written, once it comes into effect, it applies to all of your organizations. And perhaps the best way to illustrate that is to contrast that with how the federal government approached its new not-for-profit legislation. So the federal government enacted not-for-profit legislation back in 2009. It came into effect in October of 2011. And that legislation said, okay, until all federal nonprofit corporations to come into under the new legislation, you actually have to make an application. And until you make you've got 3 years in which to do it. And until you do that, you're under the old act. In Ontario, Ontario took a different approach and said, okay, once the new act comes into effect, it applies to everyone. So there's effectively no transition. The rules that will apply to your organizations on the day that the ONCA comes into effect are the rules that are set out in the Not-for-Profit Corporations Act. But they did say there is a transitional provision in the ONCA which says that, okay, you've got 3 years to basically bring your bylaws and your articles into compliance with the new legislation. You've got a 3-year period. But people were kind of left scratching their heads, saying, okay, well, that's fine. We've got 3 years to kind of get the documents into shape. But what does that mean in terms of the rules that apply? Do we still have to conform to the new legislation, or are we permitted to function as if the letters patent and the bylaws, notwithstanding the fact that they might not be conforming to the new legislation, that we can comply with, we can continue to act under the letters patent and the bylaws. So it created a bit of a kind of a gray area. And so under Bill 85, and this is the clause that I've got up there, basically it says that notwithstanding the fact that your letters patent might not conform to the new legislation, the letters patent will still be valid for a period of up to 3 years. So essentially it's saying you've got 3 years in which to get your letters patent bring them into conformity with the new legislation. And until you do that, your letters patent will continue to apply. So
Okay.
So that's one relief.
If I may ask,
Yes?
say 1 year has passed and one corporation has completely complied and the other hasn't moved an inch on it because they have 3 years and they get into a conflict in the courts. So then obviously the one who has complied is in a better shape than the one who hasn't moved an inch.
It depends on what the conflict is.
Well,
Yeah.
any conflict along these lines.
But the corporation that hasn't complied within that 1 year period is still complying with the legislation. So
Exactly.
the legislation permits it.
So it will not affect
No.
in the judgment of the court.
No,
It will not
No.
make a difference to
No.
one way or the other.
no,
Yes.
no. What happens if your organization actually doesn't make the changes by the end of the 3 years? The legislation says that in that case, your letters patent will be considered to have been amended to bring them into conformity with the new legislation. So essentially, if you don't do it, effectively the legislation will make the change. This has to do with your bylaws. Bylaws and a special resolution. So if at the end of that 3 year transitional period, there's something in your bylaws that actually should now be in your articles, and you haven't actually taken, your organization hasn't taken the steps to bring them into the articles, the provision in your bylaws ceases to apply. It's invalid. So for example, if your bylaws or a special resolution spells out the number of directors for your organization, and that is supposed to actually be in your articles, then at the end of the 3 year period, if you actually haven't amended your letters patent to put into now the articles a provision that deals with the number of directors for your corporation, the provision in your bylaw or the provision in your special resolution will cease to apply, will effectively be invalid. So it's an incentive really to get your bylaws and your special resolutions in shape and into conformity with the legislation. In terms of, I'm just going to skip through because I'm kind of aware that we're running short on time. Two things about reviewing. As I said at the outset, I don't think it's really necessary at this point to be reviewing your letters patent or your bylaws. I think organizations really should just wait and see what the regulations stipulate. And then you will have a 3 year period in which to get things in order, and assuming that the equivalent of Bill 85 is reintroduced into the legislature, you will, your provisions in your bylaws and the provisions in your letters patent will continue to be valid for that 3 year period until you bring them into line with the new legislation. Resources, and someone asked about the present. So the presentation will be available. There are some good resources on the internet. If you kind of want to follow this, take a look at the Ontario Not-for-Profit or Nonprofit Network, and also the Community Legal Education of Ontario is developing some materials, educational materials on this new legislation. So it's worth going there.